table over to both of you, and you know the process, so please proceed.
Thank you, Mr. Chair and members of the committee. For the record, my name is Eric Sylvia, nonpartisan counsel for the Senate Tax Committee, and I'm joined here with Ms. Johnson. This morning, we have put together sort of a high-level, sort of limited overview of the property tax system that sort of highlights certain components of the system, and those are namely on your screen. Talking about initially the property tax timeline, property tax exemptions, the classification system, property tax calculation, credits exclusion as forms of property tax relief, state general levy, and lastly, Ms. Johnson will share some graphs and charts that I think would be helpful to illustrate some of these topics as we move forward. At the outset, I think it's worth noting some terminology that is unique to the property tax system, but terms that this committee uses often when reviewing property tax bills. Each one will be discussed in greater detail as we move forward, but just a quick rundown. Estimated market value, of course, the likely sale price based on comparison of similar properties in a competitive and open market. So we often will talk about what a property's estimated market value will be. Also, the property's taxable market value, which in most instances will be less than the estimated market value. Taxable market value is the amount of value used in calculating property taxes, typically after subtracting property tax exclusions and certain deferral programs. Referendum market value is another term Ms. Johnson will go into a little more detail about, but it is the market value of all taxable property except ag property, cabins, and post-secondary student housing that is typically used for certain school levies. A property's classification is crucial to the property tax system. That is a designation given to all types of property according to its use. Likewise, each property tax classification is also assigned a class rate. Class rate is multiplied, or I guess I'll skip to the next term, a net tax capacity, where a property's net tax capacity is calculated by multiplying that class rate by the property's taxable market value. And lastly, a term that's very familiar to this committee, a property tax levy, and that is simply the amount of property taxes that is collected by a certain taxing jurisdiction. Except for the state general levy, which will be the topic of a later slide, property taxes are primarily local and were local until 2001 when the state general levy was established. Taxing jurisdictions are those entities that have taxing authority. And we think about sort of the three basic taxing jurisdictions, those being counties, cities, school districts. But there is sort of a catch-all special taxing districts. Minnesota statute section 275066 lists all the special taxing districts that have the authority to levy and collect a property tax. Some of the more common special taxing districts are watershed districts, park districts, are HRAs, EDAs. And one of the more recent changes to the list of special taxing districts occurred in 2021. There existed under current law the ability to form an emergency medical service special taxing district, but until 2021, political subdivisions that were interested in establishing fire protection special taxing districts needed to come to the legislature and seek special law. And in 2021, those two were combined to establish an EMS and fire protection special taxing district. It's worth noting that the concept of levy limits aren't in place, and levy limits, are set by the legislature and limit the amount of increase to a taxing jurisdiction's levy. Those are not in place. However, some special taxing districts do have within their authorization a levy limit. Typically, it would be either an amount or a certain percent of estimated market value. But that's something to note, that it applies, at least at this point, to special taxing districts only. The last time levy limits were in place were for taxes payable in 2014. And the bottom of the slide just notes what I have here is county tax officials, but really the county offices that are involved in the property tax system. Simply put, the county assessor is required to value property and determine the property's classification. The county auditor calculates taxes and computes the tax. And lastly, the county treasurer mails the tax statements and collects and distributes the tax. The property tax timeline is unique in that it is a 2-year cycle. It's sort of designed to provide taxpayers the ability to be more involved in the system, certainly at the front end with potential challenges, but also toward the latter half of the assessment year for the truth in taxation statement. In the property tax committee will often refer to the first year in the cycle as sort of the assessment year, and the second year as the taxes payable year. And for property taxes payable in 2025, those are based on values and classifications that were set in the first year, so the assessment year. And just briefly running through the timeline, in January 2nd is the assessment date. In March, those valuation notices are mailed to taxpayers. And at that point sort of begins the opportunity for the taxpayer to challenge assessments and classifications. And they do that a number of ways. The first step is the local Board of Appeal and Equalization. That is typically members of the City Council. The next step would be the County Board of Appeal and Equalization. That is typically the county commissioners. It's important to note that a direct challenge to the county board as a first step is not appropriate. One would have to go to the local board before going to the county board. And lastly, there is challenges to Minnesota Tax Court. The tax court has 2 divisions. One is called a small claims division. One is a little more formal. The small claims division concerns primarily valuations for homesteads. And it's important to note that the decision for the small claims division is final. The more formal process is open to all types of property and decisions by that side of the tax court. Those decisions are appealable to the Supreme Court. In early fall begins what we call the truth in taxation process. That was a process that was established by the legislature in 1988 to enhance public participation and provide transparency. And there are sort of 4 components to the truth in taxation system. One of these sort of initial proposed levies that each taxing jurisdiction must submit. Parcel-specific notices are mailed to each taxpayer, showing certainly the valuation and the classification, but also the amount of taxes that a particular property would likely pay if these proposed levies ultimately become the final levy. There are public advertisements, and lastly, the public hearing in which taxpayers are given the opportunity to speak directly to the taxing jurisdictions in an attempt to sort of influence budgetary decisions. The T&T process is pretty specific on the timeline when that can happen. Notices must be mailed between November 11th and November 24th, and those public hearings must happen between November 25th and December 25th. Excuse me, December 8th. Finally, on the assessment year, the last sort of step is the final levies are adopted, and that happens at the end of December. Moving to the next year, what we call the taxes payable year, tax rates are computed in early January, and then in March, statements are mailed. I think there's some confusion with some taxpayers about sort of the valuation notices and the tax statements. When a taxpayer receives their valuation notice, which is March of the assessment year, at that time is when the opportunity to challenge the assessment and the classification begins. If a taxpayer waits until the actual tax statements are mailed in March of the taxes payable year, at that point, it is too late. So there's no longer an opportunity to challenge that. It would be the current year's assessment, but not the taxes payable amount. Property taxes are payable in 2 installments, in May and October for most properties. November is an extension provided to agricultural property. They have 1 additional month in which to pay the property tax. An important topic to note is property tax exemptions. In Minnesota, all property is presumed to be taxable unless exempt. I think the phrase has often been uttered, taxation is the rule and exemption is the exception. Whenever property is exempt, certainly other taxpayers in the jurisdiction would pay a higher share of the tax burden. It may not be noticeable if an exemption is parcel specific, but if there is a certain class of properties that are exempt that encompass multiple parcels throughout the state, perhaps other individuals within a taxing juris might notice that more. Even though a property is exempt, the law still requires properties to pay special assessments. That was subject of a recent court case in the city of St. Paul concerning church property. And so even though churches are exempt property, they are still required to pay special assessments. Special assessments are a charge based on public improvement that benefits the property, so that's why it's sort of separated outside of the property tax system. There are two ways in which property is exempt in Minnesota. First is through the Constitution. Article 10, Section 1 specifically lists properties that are exempt. And I will just read them quickly. The Constitution mentions public burying ground, public schoolhouses, hospitals, academies, colleges, all churches, church property, houses of worship, institutions of purely public charity, and public property used for a public purpose. And so certainly, if there's an attempt to modify those, a constitutional amendment would be required. What is more common is property tax exemptions through statute that certainly this committee would have control over. And those exemptions are all found in Minnesota statute section 272.02. And if members were to look at that statute, you would see 105 subdivisions, so 105 different authorizations of property tax exemptions. One thing to note is that with the statutory exemptions, most property tax exemptions are ongoing, meaning they have no sunset. It's not uncommon to have a proposal that may initially recommend a sunset, and I can recall a few years ago there was a proposal in front of this committee for a specific parcel for a tribal-owned property, and this committee required a 10-year sunset. That was later extended, by this committee in the legislature. But the vast majority of all exemptions found in section 272.02 are ongoing without a sunset, but certainly that's within the purview of this committee. As is the case with all exemptions, ownership and use determine whether an exemption is appropriate. So even if there is a property that is otherwise exempt, if it's used by a non-exempt entity or used for a non-exempt purpose other than which the exemption was originally granted, then that would become taxable. Earlier this committee heard a proposal from Chair Weber concerning an exemption for certain property used for grazing purposes. And that is necessary because although certain native prairie exemption exists and the like, if that property was then leased to an entity that was not the entity for which the exemption was originally granted, there was a statute that would trigger the personal property tax because there was a lease longer than a year or used for a purpose other than that original purpose. The property tax exemption would effectively go away, and then there would be a personal property tax that would be assessed. I thought it was worth noting here on the slide some recent changes that the committee and the legislature have enacted concerning exemptions. Starting in 2023, the last changes to the exemption, there were sort of three changes. The first was, as I noted just a few minutes ago, the legislature extended that parcel-specific tribal-owned property tax exemption that had originally been enacted for a 10-year period, and the legislature extended that for another 10-year period. The legislature also established an exemption for a parcel-specific elderly living facility. This was a specific facility in the city of Duluth. This facility was unable to qualify under sort of the what we kind of call as the catch-all for institutions of purely public charity. It did not meet that requirement due to the requirement that certain amounts of rent were charged.
Mr. Sylvia, Senator Ress has a question.
Thank you, Mr. Chairman. The exemptions in 2023, those were made for a specific reason and not a general category, nor were they meant to be seen as establishing a new general category. Is that your understanding? That there was some sort of special consideration for unusual circumstances to allow that exemption to exist or come into being?
Mr. Sylvia?
Thank you, Mr. Chairman.
Mr. Chair and Senator Rest, that is correct. So within the three changes to 2023, I do note the parcel specific, and what I mean by that is that it would apply to a particular property, not class of properties. And in each instances, there were situations which the committee felt, justified this exemption. I noted for the elderly living facility, that's that facility in Duluth. I think in most instances, a facility like that would have met the exemption for institutions of purely public charity. How one of the requirements concerns the amount of rent paid, and this facility was unable to meet that requirement. So that's why this committee chose to exempt that facility, but that facility only. Did not apply to other living facilities. It was written very specifically to target that one specific property, Senator.
Thank you.
The last note under 2023, again, is a parcel-specific school property exemption, and it might be worth just providing context for why the committee felt that was appropriate. So all applications for exempt property must be filed by February 1st of the assessment year. But there are certain times where either property that is exempt should become taxable, or property is taxable on the assessment date, but at later a period would meet the qualifications for exempt status. And under those both circumstances, July 1st is an important date. So if property is exempt on January 2nd, but either a change in ownership or a change of use prior to July 1st, then that property for that assessment year would change to taxable status. Conversely, if there is, on January 2nd, the assessment date, a property that is taxable, but then it is acquired before July 1st by a tax-exempt owner, 501c3 or so, and then used as an exempt property, then it would then become exempt for that assessment year. And I note that because in 2023, there was a situation with a school district that purchased property. However, the final acquisition of that property happened in early September. So they did not meet that July 1st date by which the acquisition must have happened for it to transfer from taxable to exempt status. And so what this committee did was, again, provide authorization for just that specific property in that specific assessment year, that it would be treated exempt. Once that assessment year passed, the property would then normally be exempt under existing law going forward, so no action would be needed by this committee. It was just for purposes of that assessment year because of that date. In 2021, this committee also established, again, a parcel-specific property tax exemption for certain tribal-owned property, not a class of properties, a specific isolated property identified in a specific city. In 2019, this committee also modified exemptions and established a new one. The first I note is modified agricultural historical society exemption. And under current law, property in a county that's used for a qualifying agricultural historical society is exempt. Current law at the time required that no more than 20 acres per owner per county be eligible for an exemption. And what this change reflected in 2019 did was to extend from 20 to 40 acres. It also established a new exemption, and this is a class exemption. So this would apply to more than one property, but it would still have to meet the requirements in statute. This is for licensed childcare facilities that participate in the CCAP program. And so that did apply for more than one property, again, if the requirements were met. And I'll note that that exemption for licensed childcare facilities, again, is ongoing, so there's no sunset unless that were changed by the legislature.
Senator Nelson.
Thank you, Mr. Chair. I don't want to deviate too much from your script. You have much we need to hear. But I noticed a couple of the parcel exemptions had to do with specific tribal-owned property in your examples. And I know we have another one, I think, this year in front of us. And can you give just, I don't want to take up too much time here, but can you kind of give a brief explanation of how the tribal land property taxes and why some are specific exempt, or what those criteria are, I guess? And if it's too lengthy, Mr. Chair, I'll take a private tutorial.
Mr. Sylvia.
Mr. Chair, Senator Nelson, sure I can provide some information. So by very definition, tribal lands are exempt under the Constitution and state statute. But there are some instances where individual property will be owned by a tribe but not necessarily used either for a tribal purpose. So for these parcel-specific property tax exemptions, certainly the federally recognized tribe could have made an application to the federal government to put that land sort of in trust, and as federal trust or Native American land would be exempt. I know there's a process to do that. In these specific instances, there were situations where the tribe owned, I believe it was a pharmacy, so not necessarily a tribal purpose, it was open to the public. There was also an instance, I believe, in the city of Minneapolis where, again, a tribe owned a piece of property, but it was used as sort of a social services center, again, open to the public. So those in and of themselves would not be exempt. Absent, an application to the federal government, but because, the legislature felt that those were sufficient for a parcel-specific exemption, that's why they were enacted.
Thank you, Mr. Chair.
Thank you. And I just went back to the slide where on the right, there was a chart that Ms. Johnson put together just showing the value in millions of the types of property that have been exempted under current law. You'll see at the top, schools account for approximately just over $22 billion worth of value. So this is value, this is not property tax, but value that ultimately would be used, as this committee indicates, that sort of shifts onto other properties when the calculation is done. Next is municipal property, colleges. I won't go through them, but I will note down on the lower level, toward the bottom, there is an other category, and I'll just, for members' benefit, note what types of exemptions are within that category. And just briefly, it would be certain child care facilities, children homes, again, that elderly living facility I noted was parcel specific, recreational property, pollution control property. So just as a, for the benefit of members, know what is considered as under other. In the next slide, Mr. Chair and members, is talking about property tax classifications, which is sort of a fundamental component of the property tax system. Minnesota's Constitution contains what is often referred to as the uniformity clause, and that allows different classes of property to be taxed at different rates. So while there are several different classifications and classification rates, you'll see within each class, though, each property must be classified at the same rate. So residential homesteads, we'll go through this in just a moment, but that is how sort of the uniformity clause is interpreted. Property is classified, again, according to its use on that assessment date of January 2nd. That's done by the county assessor. Certainly, if property is improved with a structure, its use is probably pretty apparent. However, there may be instances where either the land is vacant, unplatted, or whatnot, and that's when this sort of highest and best use component would come into play. I understand that the counties probably would go into more detail concerning that. County assessor in valuing their land, in valuing the property, values the land, values the structures improvements, and then ultimately arrives at an estimated market value, which includes both the land and buildings. So although I noted at the outset that there are no levy limits, so each taxing jurisdiction has the ability to levy an amount that they determine they need to raise through the property tax system. Legislature does not have a part in that, but the legislature does have a part in setting the classifications and classification rates. In section 273.13 are where all of the property tax classifications are found, all the requirements and all the class rates. And within your packets should be this document called Classification Rates for Assessment Year 2025 from the Department of Revenue. And this shows all of the property tax classifications currently in statute, the class rate, and in the far right-hand column, you'll note reference to state general rate, so that means whether or not that particular property also pays the state general tax. But there are 5 sort of general classifications, but certainly several subclasses. They're kind of organized, you'll see, by a number and a corresponding letter. Class 1 is typically referred to as sort of residential homesteads. That would encompass both residential and ag homestead. It also includes homestead resorts. That's Class 1C. Those are the resorts that are typically referred to as kind of the Ma and Pa resorts. That's treated as such because there is a portion of the homestead resort that is used as a homestead by the owner and is classified as such. Moving down the list, you'll see Class 2 is typically referred to as the ag class. That would again include ag homestead first tier. Class 3, typically referred to as commercial. 4 is sort of lumped as an apartment, although if you'll notice that there are several other types of classifications other than apartments, but typically it is for multiple dwellings into more than just one residential homestead or a single family home. And, typically, your average apartment building would probably be classified, you'll see, as Class 4A because there are more than 4 units. And lastly, there is Class 5, which is other. In looking at this document, you'll see certainly the class and the description, but also tiers. And that's something that is important to note because some property tax classifications are subject to more than one tier and a corresponding class rate. And so looking at residential homestead, you'll see it is subject to first and second tier. So the first $500,000 of value of a residential homestead, that first tier has a class rate of 1%. Anything over would have a class rate of 500. Homestead resorts, things like that, ag homestead, all of those you'll see are reflected on the first tier.
Excuse me, Mr. Sylvia, Senator House-Child has a question?
Thank you, Mr. Chair, and thank you, Mr. Sylvia. And I apologize. I think you said this. I just want to make sure that I fully understand. You had mentioned that under 4, I think you said it was multi-unit or apartment kind of category, and now you're on 4BB1. Is that, am I reading this right? Residential non-homestead single unit, so that's a single family home, non-homestead? Or is it are we still in the multi-unit category?
Mr. Sylvia?
Mr. Chair and Senator Hochschild, so yeah, I was sort of grouping them as it's often described, and sort of category 4 is typically referred to as apartments, although it oftentimes is more than one unit. So that's why the average home, a single-family home, is going to be classified as 1A residential homestead.
Yep.
Where we get down to kind of the 4BB1, and I'll note that in a subsequent slide. A few years ago, The legislature reclassified what was kind of the VRBO home, so rental homes that were rented out. By definition, they were sort of single-family homes, but they were rented. And so we created a new classification for that sort of residential homestead, single unit, subject to a different class rate. But that could also be simply a single-family home that's rented, that's not occupied by its owner.
Okay, that's helpful. Follow-up question, Mr. Chair.
Senator Rothschild.
Thank you. So what if, kind of simple question, but what if you just own two homes and you don't rent it out? And it's a non-homestead, where is that?
Mr. Chair and Senator Hauschild, so several years ago, there were different class rates based on residential homestead and residential non-homestead. And the legislature has done away with that. So the home where you would reside and if you have homestead status would be residential homestead.
Yep.
That status of homestead is important because in order to receive the homestead occupied exclusion, the
Right.
PTR, you would need that. But that second home would be likely classified as the residential non-homestead because it's not a homestead and it's a single-family residence. It's not more than one unit. There is sort of a wrinkle there that, what's the definition of a sleeping unit? In some instances, there might be a single-family home that has, more than one bedroom, and that, depending on sort of the way it's operated, could be classified as a different rate if those are different sort of sleeping units, but ultimately it would be residential non-homestead. But because there are no longer separate classifications rates for res homestead and res non-homestead, the classification rates and the tiers would be the same.
Okay, so I'm sorry, just
Yeah,
one more
Senator
follow-up, Mr. Chair and Mr. Sylvia. So what you are telling me is that VRBOs or rented single-family homes are not designated for tax purposes on property differently than somebody that just owns a second home and doesn't rent it out. Am I understanding
So
that?
I will, Mr. Chair, just jump ahead to this slide. So you see in 2020, the legislature created this 4B1 classification, and that was designed for the situation where you have a short-term rental property. Before that change, most of these, what I call sort of these VRBO rental homes were classified as commercial. And you may recall there was some concern in how that would impact fiscal disparities
Yep.
because of the classification change. And so because they were classified as commercial, they were also subject to the state general levy. And so the legislature enacted this new class, but this is written specifically for those instances where you have a rental for a short period of time. If it is just a second home that is being rented, that is not this, it would be residential non-homestead.
Okay, thank you.
Thank you.
And moving to the next slide, Ms. Jerry mentioned the sort of 5 basic classes, but you'll note, looking at the sheet, there are certainly more than 5 classes. That's because of the several subclasses. And similar to the exemption slide, I also thought the benefit of the committee would just be interested to know some of the classification changes that the legislature have enacted. In 2023 and 2021, the legislature made several changes to Class 4D property. This is the low-income rental housing property, subject to the proposal we heard earlier this year concerning income averaging, but this is the low-income rental unit housing. Beginning in 21, the legislature decreased that first tier limit. Interesting to note, as you look at that document of the class rate changes, those that have tiers, as the property increases in value and enters that second tier, the class rate would increase. That was the opposite for Class 4D property. The first tier had a 0.75% class rate, and when you increased in value past the first tier, the class rate was substantially lowered to 0.25. That was eliminated in 2023, and so there are no separate tiers for Class 4D property, 4D1 property. It's just that one class rate at 4.25. As part of that proposal, there was a change to community land trust property. These are properties that the home or the residence is owned by the the resident, although the property is not. Prior to this change, community land trust property was classified as a residential homestead. What in 2023 happened was that the new classification of 4D2 was established, and the class rate for those types of property were set at 0.75. And also a change in 2023 was to the first tier limit for ag homestead. So I noted that several classifications have tiers. Ag homestead is one. So ag property, the homestead would be the sort of the house garage, 1 acre would be treated as a homestead. And then there is a first tier limit, which is a valuation amount. That first limit has a class rate of 0.5, and then anything over that would be doubled to 1%. The legislature increased that first tier limit. I noted 2021 was the class 4D change, and then as I indicated to Senator Hochschild, in 2020 is when that new 4B1 class was established. Again, that is very specific to those short-term rental properties that were previously to this change classified as commercial.
Mr. Chair and members, my name is Rachel Johnson, and I'm a nonpartisan analyst with the Taxes Committee in the Office of Senate Counsel. I'm going to start by talking about the two different types of tax bases that are used to calculate property taxes in Minnesota. One of them is the net tax capacity base, or NTC. These NTC levies account for about 82% of property taxes in the state. They include most types of taxing districts, state, counties, cities, townships, special districts, and they include all property types. And to calculate a taxing jurisdiction's net tax capacity, you take the total levy and divide that by the total net tax capacity of the district. The second type of tax base is the referendum market value tax base, and that's for school operating levies. These referendum market value levies account for about 12% of property taxes in the state. Agricultural, seasonal recreational, and student housing property are excluded. And a taxing jurisdiction's referendum market value tax rate is calculated by dividing the total referendum estimated, or excuse me, the total levy by the total referendum estimated market value. So this slide shows how a local jurisdiction's local tax rate is determined with an NTC base. On the top, a taxing jurisdiction is going to determine the amount of revenue that it needs to raise, and then, so they'll consider their proposed local budget and take into account other forms of non-property tax revenue that they may have, and then subtract those from that, their proposed budget. The remaining amount is what they need to raise from property taxes. And so that would be the levy. This levy is then spread onto the NTC base, and the NTC is determined by applying those class rates that Mr. Sylvia was just talking about earlier to the taxable market value of the property in the jurisdiction. And then the levy is then calculated by taking, or the local tax rate is then calculated by taking the levy and dividing it by the total net tax capacity. Now I'm going to talk about a couple of mechanisms by which taxpayers can receive property tax relief, starting with exclusions. An exclusion excludes a portion of a property's market value from taxation under specific conditions. Because they reduce taxable market value, they shift property taxes onto other properties in a jurisdiction. So one example of an exclusion is the homestead market value exclusion. This exclusion applies to property classified as residential homestead, and then also to the portion of agricultural homestead property that consists of the house, garage, and surrounding 1 acre of land. The exclusion amounts are based on the market value of an eligible property. In 2023, the legislature passed an increase in exclusion amounts and to the eligibility threshold. This is going to be effective starting with property taxes payable in 2025. With this, for homesteads valued at $75,000 or less, the exclusion is 40% of market value, and that gets to a maximum exclusion amount of $38,000. For homesteads valued between $95,000 and $517,200, the exclusion is $38,000 minus 9% of the amount of valuation over $95,000. And then there's, once you reach $517,200, $200 of value, there is no exclusion. In 2024, approximately 1,123,000 homesteads received this exclusion. Due to the 2025 changes, the number of homesteads receiving this exclusion is expected to increase to 1,320,000 in 2025. There were also some recent legislative changes to the homestead market value exclusion for veterans with a disability. This exclusion applies to qualifying disabled veterans, their surviving spouses, their primary family caregivers, and the surviving spouses of service members who died while serving honorably in active duty. Under this exclusion, either $150,000 or $300,000 of market value is excluded from taxable market value. In 2020, the legislature enacted a change that allows surviving spouses to make a one-time transfer of the exclusion to a different property. In 2019, the legislature established a potential lifetime benefit for surviving spouses. And in 2024, approximately 25,900 parcels received this exclusion. Credits are another property tax relief mechanism, and those are paid from the state general fund to local governments as an open appropriation. They're applied after calculating the amount of a property's gross tax, and so they do not reduce the size of a taxing jurisdiction's tax base, and therefore they don't result in a shift of tax burden within a jurisdiction. Minnesota statutes 273.1393 is where you can find a list of all the different credits and the order that they're applied to the tax calculation. I'm gonna highlight four that are commonly discussed. One is the agricultural homestead market value credit, and that is a proportional credit on the value of agricultural homestead, not including house, garage, and surrounding 1 acre. And the maximum credit is $490. In pay 24, 37 million was spent on this credit. The school building bond agricultural credit is a proportional credit on property tax attributable to the school's debt service levy and was 109 million in pay 2024. The disparity reduction credit reduces taxes on 3A and 4A property to 1.6% of taxable value in certain border cities and was 13 million in pay 24. And finally, the taconite homestead credit and the supplemental taconite homestead credit reduced taxes on homesteads in certain taconite mining areas, and together were 17 million in pay 24.
Mr. Chairman?
Senator Housechild.
No, go ahead.
I'm sorry.
Thank you, Mr. Chair, and thank you, Ms. Johnson. So can you tell me more about the school building bond agriculture credit? How does that work and what is it?
Ms. Johnson?
Yeah, Mr. Chair, I'm gonna have to do a little looking here.
We can talk offline, that's okay.
But
Ms.
yeah, I mean, I can also, so
Yeah,
Class 2A, 2B, and 2C property is eligible, other than that property consisting of the house, garage, and then immediately surrounding 1 acre of land. The credit amount for qualifying property is equal to 70% of their eligible net tax capacity multiplied by the school debt tax rate determined under section 275.08. And I'm happy
Yeah.
to follow up further.
thank you.
Very good. Senator Rest.
Thank you, Mr. Chairman. Years ago, there was discussion, argument, whatever you want to call it, on property in the taconite area. In the taconite credit itself, and then the homestead credit, as it was called in that time, some years ago. And the argument was which one was going to be applied first. And I wonder if you'd give us a little bit of history on who won.
Ms. Johnson?
Mr. Chair and members, well, I'm going to look at 273.1393 and see the order in which these credits are calculated. So was let's see, the taconite homestead credit is the ninth kind of in the order of calculation. And what was the other one that you wanted to?
Just the regular homestead credit?
So
There
my
was an
understanding-
argument about which one was going to be applied first, offset by the one that was going to be applied second.
Mr. Chair and members, this kind of gets me to my next slide because, so the taconite homestead credit is a credit and the homestead credit was a credit, but when the homestead exclusion was enacted, I believe in 2011, it became an exclusion. And so as an exclusion, it is in a way kind of applied first and results in a shift.
Thank you.
Okay.
I
Thank you,
think we
Ms.
see
Johnson.
who won.
Pardon?
I think we saw who won.
Yeah. Ms. Johnson?
So, Mr. Chair and members, kind of to that point, I said several times, exclusions cause property tax shifts and credits do not. And this is because of how and when they're applied in the tax calculation. So if you look at the top, you'll see taxable market value is computed by subtracting exclusions from, and this is simplified, exclusions from estimated market value to get that TMV or taxable market value. So if you have two properties and they have equal market value, but one qualifies for an exclusion and the other one doesn't, the property with the exclusion is going to have a lower taxable market value. This taxable market value is then multiplied by the class rate and by the local tax rate to calculate the base or gross amount of tax. So if we think about this on the level of a taxing jurisdiction, when an exclusion is applied to the estimated market value of all eligible properties in that jurisdiction, the jurisdiction's total taxable market value decreases. And so that also results in a decrease of their tax base. And then, we talked about how levies are spread on that tax base. So because this net tax capacity is now smaller, the tax rate increases, and that increases the tax burden on properties that did not receive the exclusion. Credits, on the other hand, they're applied after the calculation of gross tax. They do not reduce a jurisdiction's tax capacity, and they do not result in shift in property tax burden within the jurisdiction. After the gross tax is calculated, credits are subtracted from this gross tax and other taxes, including the operating referendum, bonding referendum, state general tax are added, and then you can, calculate the total property tax.
Senator Houschild?
Clearly, thank you, Mr. Chair. Thank you, Ms. Johnson. I'm clearly infatuated by this conversation. So I just want to make sure I understand something that's unique to my district. So when we go back a couple of slides, we're talking about exclusions for school operating levies. And on there, we have seasonal recreational property. So if I'm understanding correctly, based on this slide, seasonal recreational property for school levies is considered an exclusion first in that local jurisdiction, which means not only are those seasonal recreational properties exempt and not paying into that local school levy, but it's shifting the burden onto the other properties in that local jurisdiction.
Ms.
Am
Johnson?
I getting that correct?
Mr. Chair and members, I may need more clarification, but I wouldn't say, I don't know that unless, if I'm thinking about the right thing, I wouldn't necessarily say it's an exclusion, but
Okay.
Seasonal recreational property is not included in the referendum market value levy, but it is included in the state general levy tax
Okay.
base.
Okay, that's helpful. Okay, thank you. That's,
Ms. Johnson?
Mr. Chair and members, let's see, where was I? Oh, okay, perfect. So kind of again to that question, I'm going to talk a little bit about now levies, starting with the state general levy. The state general levy was established in 2001 as a part of a larger property tax reform that happened in that year. Counties collect the tax and it goes to the general fund. So the state general levy is actually two separate levies with separate dollar amounts. One is applied to commercial, industrial, including public utility property, which I'll just call CI property, and the other is to seasonal recreational property. The CI levy is about $717 million, and the seasonal rec levy is about $42 million. For CI property, the first $150,000 of market value is excluded, and for seasonal recreation, the seasonal recreation levy, specifically for cabins, only 40% of the first $76,000 in market value is subject to tax. When the levy was first enacted, there were annual inflationary increases each year. And in 2017, the legislature removed the annual inflationary increase and decreased the levy amount. The legislature again decreased the levy amount in 2019 and 2021. So I'm gonna draw your attention to the graph, and that shows that for both levies, there has been fluctuation, but generally since around 2013, 2014, they have been decreasing. And you'll notice decreases too as levy amounts are decreased.
Yes, Senator Nelson.
I don't know if you'd have someone might have this answer, but I'm thinking about this 2001, when we instituted this statewide general levy, which really isn't a property tax, I don't think. It doesn't go to those taxing jurisdictions. But my question is, what was, if it's not too far afield, what was the history on that? Were we not in a horrible budget deficit, and this was this a way to solve this budget deficit? Why would we start taxing local businesses with a statewide property tax that doesn't go to the jurisdictions, comes right up here to the Capitol, and it's just part of our budget? Were any of you, do any of you have that history? Why did we start doing this?
Ms. Johnson?
Mr. Chair, Senator Nelson, and members, so I don't know a ton of details, or really any details, on the political situation in 2001, but I will say that was at the time when the state took over the school operating levies, or is that the correct? General, yeah. General levies, and so this property was excluded from that. And there was also compression of class rates and other changes that happened at that time.
Thank
And
you.
further answer to Senator Rest.
Thank you. In 2001, Jesse Ventura was the governor, and this is the biggest change that came about in the 2001 tax reform. And it had to do with a burden statewide on businesses and seasonal rec that those two property classes thought was unfair with regard to the paying for the schools. So we, as part of his plan, removed that and moved it to a state general levy rather than a school district by school district levy. But the proviso was that the revenue from that change was going to support the schools. And so it was then spread across, could be spread across the whole E12 system. 2002, we came into a different era, and Governor Pawlenty said, no, we're not going to give that. We're not giving those dollars to the schools. They'll just have to do. Instead, we're going to transfer it all to the general fund. And that was, under his administration, a very, I'll call it a very bold move to do that. But since that time, the argument has always been, is it going to be a flat amount that changes with inflation or by a decision of the legislature with the support of the governor, or is it going to be subject to an inflationary factor. And so that, we don't talk about it a whole lot because it's been in place for over 20 years, but that was the debate at the time. At the time, the business community was asking about winners and losers, or at least winners. At the time, the business community thought they were winning. Almost immediately after the dollars were taken away from supporting K-12, the business community started having second thoughts, and it's always been since then a discussion about whether that is a fair way of bringing property tax on commercial industrial property and seasonal rec property, which in some areas is almost equal to the notion of it being their commercial industrial property. And we have just never found a way that meets the goals of support, even though it goes into the general fund, of having a positive impact on the on school districts without without undue burden on those other two property tax classifications. And you know, hindsight provides clearer pictures often, but not so sure it does in this instance. But that's where we are. That's where the state general levy came from. It is assessed on all the market value or the taxable value, however they get to it, of CI property and seasonal rec. It was actually a very exciting reform, but it hardly lasted a single year before support for the schools was, the general levy was gone, but the money was needed to support the general fund and not our school districts.
Senator Dibble.
Thank you, Mr. Chair. I'm glad you called on Senator Rest first, because I was going to try to recite some of the history, and she did a better job than I would have. I'll just add a couple. I
I'm
think we're the
older.
only two who were around at that time. I was in the House, or the other body, and Senator Rest was over here. I'll just add just a tiny bit. The deal, she described the terms of the deal that was struck with the business community at the time in the context of that very large tax bill, which had a lot of reform elements. At that time, everyone was running around calling it the second Minnesota miracle, which it might have been had we not had it unwound immediately by the next governor. And then also adding to the deal was what we call property tax compression, collapsing some of the commercial industrial as well as multifamily property tax classifications, out of which they got substantial relief as well. I think a couple of thoughts come to mind in this conversation. One is right to the point that Senator Nelson makes in asking her question. We now have, all these years later, regular conversations in our meetings with the business community about just getting rid of this random property tax that goes to the state. Because conveniently, the other side of the deal was that business and commercial industrial property taxpayers continue to have some responsibility and obligation for paying for our public education system. They got out of, paying it at the local level, but first directing it specifically to education purposes, then ultimately to the general fund. At some point, it kind of finds its way into, of course, E12 public education, other services that are supported by the general fund. We also have a lot of conversations about how do we construe it? You know, should it float with property value? Should it be a set amount? Should it be indexed to the CPI, et cetera? Those are fine conversations to have. Just so long as we keep in mind that, you know, we're all part of a larger enterprise in which we succeed or fail according to how well we provide basic essential government services like educating our young people. The final thought I have is this is a warning. We had similar kinds of reforms in the transportation arena at that time, where, you know, there was a big takeover of transit funding in the metro area, and that was going to be taken over by the general fund, immediately got wiped out, and for 2 or more decades, we struggled to just maintain the minimal level of funding we needed for transit in the metro as well as greater Minnesota. So once you cast your fortunes in the general fund, then you're part of the general fund scrum, and, you know, it's the people with the sharpest elbows or the most powerful legislators around here who prevail in that squabble. So, so as we look at these sorts of changes in the future, just be aware. Thanks.
Senator Nelson?
Thank you, Mr. Chair. It's a great history lesson. And much of that was before my time here, but I could also recall, as I'm listening, that perhaps those pieces, as we were talking about I call it the misnamed statewide general levy, but the state general levy, was maybe part of that Ventura big plan, specifically with the education piece. But then I'm also thinking about the dates, and I think Governor Pawlenty was elected in 2002, and so I'm kind of back to my original question. So the Ventura plan was using the statewide general levy for education. 2003, we get a new governor, but if I do recall, at that point, back to my question about a deficit, I think we were facing a $4.5 billion deficit at that point in 2003. And to Senator Dibble's point, suddenly this became part of the general fund in solving that budget deficit, is what is my understanding of what I'm hearing here from those who were here before I was. But I do think it is a cautionary note, again, to what my colleague on the right said here. We are facing now, in the preceding budget, a $5 billion deficit. So to that point, all of these things in the general fund are going to be under a lot of scrutiny. And so I don't know, I think this might have been a cautionary tale, and I appreciate my colleagues filling in some of the history that I did not have.
Okay, Senator Rest, to that point.
Sure, I agree with you, but that $5 billion for 28, 29 is also illusory. It doesn't have to be that, we know that, and shame on us if we don't make sure through our policies in this biennium and this biennium's budget that potential right now in a fantasy world is realized, or whether we can put a stop to it. And I think it behooves all of us to think about ways to do that.
Senator Drazkowski.
Thank you, Mr. Chair. Ms. Johnson, Mr. Sylvia, how many states have this state general levy?
Ms. Johnson?
Mr. Chair and Senator Drazkowski, I'm not aware of the answer to that question, but I can look into it and provide that for you in the committee.
Thank you, Ms. Johnson. I believe it's one, Mr. Chair. I think we're the only one. But I'd be interested in Ms. Johnson's research to verify it. Thank you, Mr. Chair.
Senator Huschild.
Thank you, Mr. Chair, and a fascinating discussion. I think the folks in the audience came for a drama scene here, but I just want to talk about how bad of a deal that was, not necessarily for the purpose of creating, you know, the initial plan that Governor Ventura had, but for my region in particular, where we have a heavy seasonal recreational base of properties. First, the deal was, well, we're going to take that and we're going to put it in the fund that's then just going to get dispersed to all the school districts. Then the rug was pulled out and it's no longer going to schools at all. Meanwhile, a news report in 2022 says that Aurora Hoyt Lakes, which is in Center Farnsworth in my district, is the poorest community in the state, which is a community that is surrounded by mining of which provides 80% of the funding to the school trust, which then gets dispersed to all the schools in the state. But we can't tax the wealthiest people in our districts to fund our schools. So we send our mining dollars to the school trust to get dispersed to the schools. We send our wealthiest residents' property taxes to the state to fund the general fund. Meanwhile, the poorest communities in the state can't fund their schools because we can't pass an operational levy for our school districts. And Wayzata, and Minnetonka, and Edina, no offense to anybody, but they go on and pass huge operational levies in addition to the high wealth that they have in their communities to fund their schools. It's incredibly inequitable. It's the opposite of the Minnesota Miracle, and it's screwing my communities. And that's why I have my proposal this year and last year to bring back those seasonal recreational properties back to the tax bases where they reside so that the wealthiest members in our community are paying for the schools for our kids. So, Mr. Chair and Madam Chair, I hope that the seasonal recreational property bill can get heard, and I really hope, despite our budget challenges, that we can look at making sure that they go to the school districts where they reside so the wealthiest members in our community are paying for our schools again. Thank you.
Mr. Chairman.
Senator Rest.
Thank you. As in every discussion, there's more than one side, more than two sides. And I can tell you that back in that time, my district had more seasonal rec property owners than any other district in the state. They were upset about how they were being charged property taxes to support schools on the Iron Range, as well as schools where they lived. I had a town meeting. This is 20-some years ago, okay? I had a town meeting, and usually there'd be 20, 25 people there. At that one, there were 500 angry seasonal property owners. And so there's more than one side of the coin of who is supposed to support local schools when they get no benefit in their own minds. Now, there's a societal benefit, obviously. We want every child educated as best we can, regardless of their zip code. We have, that's kind of a mantra in Minnesota. Nevertheless, sometimes it's a bridge too far. And Ventura's reform was not necessarily, or it didn't last, obviously, but it was certainly his attempt to even that out somewhere. But what's happened since then, Mr. Chairman and Senator House-Child, is it's kind of fallen on its face. And that's why we should be listening to other ideas about funding the schools, but respecting property taxpayers of any kind of property all over the state. And we still, unfortunately, have a long way to go in doing that.
Members, I appreciate the discussion, but we do have other people who are
Yeah, I
wishing to
know.
present
Sorry.
today. And so we are going to stop this discussion right now and allow staff to finish up and to get to our other testifiers. Thank you.
Mr. Chair and members, there's 2 slides left to our presentation. So in 2024, property taxes made up 26% of the $46.52 billion in state and local tax collections across all tax types in Minnesota. Taxing districts in the state levied a total of $12.8 billion, and this chart shows what percentage of that total was made up by each type of district. You'll see there's a fairly even split between school districts, counties, and cities and towns. special taxing districts, the state general levy that was just discussed briefly, and other local levies make up between 2 to 4%. Finally, this last slide has two graphs that show trends over time for 4 types of properties. Residential homestead is in green, agricultural homestead, which includes ag homestead and land, and the ag homestead HGA, so the house, garage, and surrounding 1 acre of land, is in blue, CI is in purple, and ag non-homestead is in red. So the chart on the left shows the change in estimated market values statewide from 2010 to 2024 for those categories. The chart on the right shows effective tax rates over time. The effective tax rate is calculated by taking net tax and dividing it by estimated market value. Net tax is the tax due after applying all credits, programs, exemptions, deferrals, and exclusions. So using net tax to compute an effective tax rate is a way to compare tax rates across different types of properties and tax bases. You'll see the CI rate has had kind of the most variation over time and is substantially higher than the rates for other types of properties. Overall, the effective tax rates have been fairly steady as estimated market value has increased. Variation in tax rates, either looking at changes for one type of property or comparing property types, can be caused by a lot of different things. Class rates, changes to class rates, which tax basis of property, type of property is subject to, and exclusions and credits can all affect those effective tax rates. So, Mr. Chair and members, that concludes our prepared slides, and we're able to answer any additional questions that members may have.
Thank you so much for your presentation. Members, if you have further questions, I would encourage you to contact staff directly, and perhaps it can be, the information can be shared at a future meeting, Madam Chair. But right now, we do need to get on to our other testifiers. Thank you again. Next, we have from the Minnesota Association of Assessing Officials, a presentation by Josh Hoagland, Hennepin County Assessor, and Mike Shepley, Martin County Assessor. And so, oops. There we go. With that, welcome to the committee, gentlemen. Please identify yourself at the start of your presentation, and Mr. Hoagland, you may proceed.
Mr. Chair, Senators, my name is Josh Hoagland, Hennepin County Assessor. I'm also the Chair of the Legislative Committee for the Minnesota Association of Assessing Officers. And if I may, Mr. Chair, I'll let my colleague introduce himself.
Okay. Mr. Chair, members of the committee, my name is Michael Shepley, the Martin County Assessor. Martin County is in the center of the state, one of the border counties next to Iowa. Mr. Weber, members of the committee, MAAO is comprised of hundreds of county, city, and local assessors, appraisers, property tax administrators, and specialists. MAAO is a nonprofit, educational, and professional organization dedicated to the improvement of ad valorem property tax assessment administration in Minnesota since 1949. MAAO's vision is to be recognized as a statewide leader in assessment education, mass appraisal training, and the dissemination of information of mass appraisal and property tax administration. The assessment process, if we were to look at a typical year in an assessor's office, if we start out in winter, we are currently working on final values and classifications for the most recent January 2nd assessment date. We are finishing homestead and exemption administration and preparing to mail valuation notices in mid to late March. Spring will find us completing Department of Revenue PRISM reporting, responding to taxpayer questions, and working through the local and county valuation and classification appeals process. As we move into summer, quintile property inspections and new construction data gathering will become our focus. Fall and winter bring the opportunity to work with sales ratio and market analysis to align the new assessment with market conditions. A number of statistical measures inform the assessor to achieve equity and uniformity. The Department of Revenue has the final review of our resulting assessments. The Truth in Taxation in November and December is an opportunity for taxpayers to understand how budget and levy will affect the tax attributed to their property. Taxes are paid on this assessment in the following year, and then the process begins again. An important takeaway from this cycle, as shown in our example, is that taxes that are paid in 2026 had their basis for valuation established by market conditions 2.5 years prior, with sales from the fourth quarter of 2023 and three quarters of 2024. In seasons of steep or rapid value change, this requires an extra level of education to help taxpayers understand how those market forces impacted their value and the resulting tax today.
Mr. Chair, if I may, Mr. Shepley and I are in a unique and honorable position of trying to explain the system to taxpayers directly. So what I'd like to do is share a little bit of some of the ways that we do that, some of the complexities of the system that we have, and highlight a few of the different areas that contribute to the eventual actual tax bill that a taxpayer might see. And as you can see on your screen, we've simplified basically an example of a shift. What this property, or what this example looks at is a simple four-house town, a simple levy across all authorities, a flat levy year over year, and then variable value increases. The pie chart on the right represents basically the whole of the levies. The levies are in theory always made whole from the taxing, for the taxing authorities from the tax base that exists within each of those. And if we look at each one of these homes in this four-house town, the top home is looking at a $50,000 increase, 50%. The resultant tax based on their share of 29% of the total levy is a 16% increase. The second home is looking at a flat value. And due to that flat value and the shift to other property owners, that property's looking at a 20% reduction in their total tax. The third home is looking at a 25% increase. Again, due to that shift, they're looking at a 4% reduction in their actual tax bill. And then the last home is looking at a 40% increase, which looks at an 8% increase. This example is a nice way to show people that value changes and increases in value or reductions in value don't necessarily equate directly to that exact same percentage change in taxes, which I think is a concern for a lot of individuals. I also want to highlight that if I were to receive an assessment like this that showed such variable degrees of increase, I'd probably have some questions for staff. But I highlight this just to show how we try to explain some of those impacts of some of the different factors to taxpayers. On this slide, as Mr. Sylvia and Ms. Johnson highlighted, you can see our classification rate table that we're led by from the Department of Revenue in determining how properties are used and eventually how they're taxed as far as classification is concerned. But I want to highlight some of the factors that go into that eventual tax bill, all of which are outside of the authority of an assessor, just to make that statement. Market forces in the real estate market, how those are reacting in different sectors are part of that equation. Policy decisions by this body here are part of that. Levy decisions from the local government, the taxing authorities are part of that change. And then other areas that are less assessor areas, but important as well, are fiscal disparities. We have a lot of communities within Hennepin County that are converting from historically agricultural communities to developed communities, and they're discovering fiscal disparity impacts now. And then tax increment financing decisions by local jurisdictions. And another area that Ms. Johnson and Mr. Sylvia highlighted are a lot of the different areas within statute that can impact that tax bill and the specific property and the specific circumstances. These are really highlighted as the levers that the legislature has the authority on in determining burden versus benefit. They were highlighted in detail already, so I will spare you that level of detail here, but in large part exclusions, as an example, homestead market value exclusion, exemptions, which were discussed, deferrals such as the Green Acres program or the agricultural program, and special classifications such as the 4D change that occurred. Some of the consequences of this are obviously going to be a shift. We also have other authorities such as the Supreme Court, which may interpret law a certain way and require assessors then to administer it that way. And a good example is a recent decision based on low-income housing that exempted low-income housing units, and assessors are in a difficult position right now of administering some of the cascading effects of that law, including personal property taxes on the tenants of those low-income housing units. Administratively, it's going to be extremely complicated for assessors to be able to do that. And I want to take an opportunity as we discuss this to issue the support of Minnesota Association of Assessing Officers and finding a solution for that and ensuring that assessors aren't responsible for taxing tenants of low-income housing units. With that, just a couple of examples that I think are important in the real estate market today that are impacting some of what we've talked about. It's been discussed a little bit, but seasonal recreation and more generally lakeshore in specific. Many people remember the historic real estate market that we experienced back in 2021 that impacted the 2022 assessment. For many, many residential properties that started to stabilize and we saw flat to slightly up values. But lakeshore and some of the seasonal recreation continues to see those pretty significant increases in value based on the sales activity that's occurring. And another one that tends to be in the headlines recently are related to office towers in the commercial market. I don't think that there's any denying that the office tower market is experiencing difficulty right now. It appears that it's going through a market reset. We've seen a lot of headlines related to reinvestment into those properties, which we are monitoring. I do want to highlight that overall, the office tower market is a portion of the commercial market. In Hennepin County, the commercial market is still buoyed in large part by smaller owner-occupied office, retail, other sorts of commercial property. And when we look at the exorbitant amounts of decline in sale prices in office towers, we're still seeing, in many cases, positive increases in other commercial sectors within Hennepin County at least, which is what I can speak the most to. Mr. Chair, if I may, I'd like to hand it to my colleague.
Very good.
Mr. Chair, members of the committee, in the agricultural sector, ag land values are at historic sale prices and continue to climb, surpassing the high values of 2012. High land prices contribute to the difficulty for new or beginning farmers to establish a base for their farming operation. We've seen a consolidation of farmland into fewer already established owners and operators. In Martin County, ag values are 72% of taxable market value, a disproportionate but not uncommon representation of market values in rural counties. Changes in aid reductions or rates are compounded for smaller tax bases. Also, recent valuation increases in the ag tax base have far outpaced valuations of commercial, industrial, and residential properties, causing tax shifts to occur. Some of the recent tax shift was due to the homestead ag tier increase to $3.5 million, while the homestead market value exclusion helped some residential homestead taxpayers, but not to the same extent. So commercial, industrial, and non-homestead properties are bearing the brunt of the recent tax shift in this current market in Martin County.
Mr. Shepley, if I have a question for you.
Yes.
In my district, we're starting to see solar companies coming in and buying outright or leasing land for well above normal agricultural rates. So if you start to see a few 100-acre tract now covered with solar panels, Number one is how are you going to consider a sale of that property at substantially above agricultural rates? And number two, what is the classification of that property going to become for real estate tax purposes?
Senator Weber, we have a great current example of this in Martin County. There's a planned 1,500-acre solar installation that's scheduled to go online in 2027. So I've had the opportunity to look at the taxing implications of that. Currently, much of that land is going to be a lease situation rather than a sale. So those leases are from the solar company to the farm owner. But the taxes currently on much of that farmland is currently at a homestead class rate, which is a 0.5% class rate, about $56 an acre. When the property is operating as a solar installation, the value of that property will remain as ag land value, but the classification changes to commercial, which is a 2% class rate, causing the property taxes to increase from the $56 to about $225 an acre.
Thank you, Mr. Shapley. From a value standpoint, if rental of that property is greatly exceeding the normal agricultural rent market, is there, and I recognize you may not have the sale data to base this on, but isn't it also safe to believe that the value of that land will have increased as well? Just because of the income that is being generated there?
Senator Weber, our approach to value is a sales approach on ag land in most counties, although all three approaches can be considered, but most weight is put on the sales approach to value rather than the income approach to value. So nothing forcing assessors to value an income approach, but we look at all three. Generally in our county, the sales are what wins out.
Okay. Then one other instance, and so in that scenario, just to finish up on that, in that scenario, the increase of the tax rate to commercial rate essentially will not create any shift on other property, but actually will cause that property to absorb more of the real estate tax burden because of the levies, and actually remove it from other properties in the county, correct?
That's correct, Mr. Weber, yes.
Then if we go to the, another situation, we see an increase in the purchase of land to take it out of production and to put it into conservation purposes, and whether it's Pheasants Forever or other organizations similar to that. And in some instances, they're coming in and also paying the values that are in excess of what I would consider the agricultural market value of that property. So in that scenario, how do you handle those particular sales, Mr. Shapley?
Senator Weber, in statute 273.117 is a conservation property tax valuation statute that states that land that is, the assessor won't change, shall not be reduced by the assessor for conservation restrictions that are recorded, and that where the property is being used for conservation or easement purposes, and that was dated after May 23rd, 2013. So for more recent conservation sales, that conservation easements that are recorded since 2013, a value reduction is not permitted by the assessor. For those that are not recorded easements, we continue to look at use and try to find sales of comparable property and value according to that use.
So what about the sale itself to a charitable organization? Are those sales considered in your sales study to establish value?
Senator Weber, they are not excluded. They are included if they were farmed at the time of the sale. They would go into our ag land sale ratio analysis. If the entity purchasing, though, is an exempt entity of some kind, they would not be included in the sales ratio analysis.
Okay, thank you. And then finally, in the case of the buffer strip legislation that was passed by this state, land that legally cannot be tilled, how do you approach the values for that purpose?
Senator Weber, we're currently having that discussion around the state with assessors, and we are discovering that there's variable ways to do that. Some of the land we're discovering has not changed in its use. For instance, it could be continued to be farmed as for hay or alfalfa, similar to the adjacent land that it abuts to. In my county, where there is a change in the use from a row crop to a grass use as a buffer, we have lowered that value to more of a waste type value that we can use around the county.
Okay. All right, very good. Thank you.
These helpful charts on agricultural homesteads detail the qualifications needed to qualify for ag homestead. The identification and administration of ag homestead is one of the most difficult and time-consuming tasks for property tax administrators in predominantly ag counties. It is also one of the most difficult parts of the tax calculation for ag property owners to understand and monitor from year to year. Accurate administration requires continuous knowledge of owners' residence, family relationships, ownership and entity changes, and operator participation and qualification. We rural property tax administrators thank you in advance for not adding to its complexity. Checks and balances. You may have seen a different version of this comparison where each party has their own opinion of that home's value. But this version represents our goal as assessors to bring uniformity, conformity, and understanding to the valuation process. Assessors are not alone in this process. We are held tightly to sales ratio constraints requiring measurements of median at 90% to 105%, as well as measures of equity and uniformity. The DOR is actively engaged, providing general oversight, sales ratio data, and guidance to apply statutes uniformly. They can and have required corrections to an assessment. The State Board of Assessors promotes public trust in the Minnesota property tax system and provides oversight of assessor licensing, continuing education, and ethical conduct. Taxpayers have significant power in this process as well. They have available to them formal appeals at the local and county boards of appeal and equalization. They can continue or bypass these appeals altogether, and taxpayers is to talk with your assessor. Many questions are answered and issues are resolved through informal conversation. Assessors desire to make each assessment fair and equal. Taxpayers can gain understanding of a very complex tax system. All parties share in the responsibility to review and maintain accurate data relied on to establish values. At this informal level, changes that affect value or classification can be made if necessary, and a taxpayer may decide that a formal appeal may not be necessary. Personally, the most rewarding part of my job as county assessor is to turn an adversarial interaction into an accepted understanding of statute, process, or data used to arrive at a value or tax conclusion. Policy considerations. Limited market value doesn't reflect market forces and strays around from free market concepts. It can cause taxable value and tax increases in declining market conditions. It creates potentially unintended benefits. For example, it may provide relief for the fastest growing values, such as lakeshore cabins, by capping their value gains despite market conditions, while then increasing levy burden for the homeowners that aren't around the lake with the same access to equity. Mr. Hoagland has already commented about low-income housing exemptions, exclusions, exemptions, and deferrals. We appreciate you, Senator Rest and Senator Weber, for the bipartisan awareness of the impact of shifting property tax burden. Shifts can result from the exemptions, rate reductions, or exclusions. Many of these are for great purposes but are paid for not by the state, but by the tax base. An over-reliance on this can really have an expounding effect on property tax burden, and we really appreciate your hesitancy on this. Shifts are not equal around the state because the tax base is so varied. For example, the disabled vets exclusion particularly hits rural county communities with low populations and VAs. In Carlton County, it's over 70 million of value excluded, or a loss of 574,000 in tax levy that is shifted onto other homeowners and veterans. This concludes our presentation. We'd be willing to try and take some questions.
Thank you both very much. One question I have yet is, I believe in the case of, I think, all the property types, your sales study ends September 30th of the year. Is that correct?
That's correct.
And if I remember correctly, if we go back to the 1980s when we saw ag land values fall out of bed, as the saying goes, it seems to me there was an extension of that sales study period to allow for some impact of more current sales, which were reflecting that downturn. Is that type of an extension, I'm assuming that can be granted by the Department of Revenue, am I correct?
Senator Weber, that is referring to something we call as a market condition adjustment or a time adjustment. And what that the effect that that has in a rapidly increasing or declining market is to reprice those sales, statistically reprice those sale prices to the current assessment date of January 2nd, and then do our analysis from that starting point. So yes, that's still in effect and being practiced.
Okay, very good, thank you. Senator Drazkowski, you had a question?
Quick question, Mr. Chair. This is the first I've heard about the low-income housing court case. Would that be worthy of us to do maybe a deeper dive in a future committee hearing?
Possibly, it's something that I can visit with Senator Rest about.
Thank you, Mr. Chair.
Very good. With that, gentlemen, thank you so much for your attendance here today, and we appreciate your information.
Thank you, Mr. Chair. Welcome. Thank you.
Thank you. Next, we're going to turn to a discussion of resort values. And we have with us three different resort owners and Mr. Joel Carlson. And so at this point, we're going to start out with Beth Klinsky and from from Knotty Pines Resort at Nevis. And just for everyone's information, when I was chairing the property tax subcommittee, we became aware of, I think, some issues as results around resort valuations, and particularly with the substantial increase we've seen in lakeshore land as well. So today we're going to hear some presentations from them, and Ms. Klinsky, please, you may start. Excuse me, Mr. Carlson, did you wish to start?
Mr. Chairman, I think I might lead it
Okay,
off for
very
us,
good.
if that's okay with you.
Yes.
Thank you, Mr. Chair and members. Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I'm here on behalf of the Community of Minnesota Resorts, an organization I've represented since 1997. And when I first started out, we had about 1,100 resorts in Minnesota. Prior to that, in our heyday, we had over 3,000 resorts in Minnesota. We're down to under 600. And that is a significant problem because resorting and resort lodging is the lifeblood of tourism in a lot of greater Minnesota. And so the decline in resorts is a genuine problem. We're here to talk about the resort property tax system. And in the mid-2000s, after kind of complaining, I love the assessors, and I'm not here to complain about their report, but valuing resorts on highest and best use is very unfair to the resorting community as a business because they value them as being broken up and sold for individual development. That's not how resorts operate. And so in 2005, the legislature, recognizing that, developed a tiered system for resort property taxes. While we appreciated that relief, those tiers haven't been adjusted for a long, long time. And to give you an example, the first tier value takes up about 60 feet of lakeshore right now. Our legislative priorities, although we care about broadband and education, our priorities number 1 through 10 is trying to get a handle on the resort property tax system because we are losing resorts for private development, which is great, but resorts are the way your constituents get to enjoy our great outdoors, and we want to remain a destination for outdoor tourism. We want to continue to be the land of 10,000 lakes and not the land of 10,000 lake accesses. And so I think Mike Schweeder from Boyd Lodge is going to go, and then Beth, and then we have one more after that. Thank you, Mr. Chair. We're happy to answer questions, and I appreciate you reaching out to us to talk about this problem. We need relief badly on this issue so that we can continue to stay in business. Thank you.
Thank you. And with that, Mr. Sweeters, please identify yourself for the record, and you may proceed.
Thank you, Mr. Chairman. My name is Mike Schweeters. I'm here with my wife, Ruth. We have Boyd Lodge up in Cross Lake, Minnesota, and I am also the past chair of the Community Minnesota Resorts. I've actually had the pleasure of talking with this committee in the past, and just wanted to kind of explain, all of our members are mom and pop resorts. They live there, work there. We celebrated our 90th anniversary this last summer that my grandpa started back in 1934. And obviously values are changed a lot since then, but we've really seen since the pandemic, property values, especially lakeshore property values. We're Crow Wing County. Our values have increased significantly. I would say they've doubled since 2000, since the pandemic ended, and in some areas even more so. The tiers have not been adjusted during this period, of course, and that's why we're here to ask for your support and help on that. Where you kind of think we would initially set up was a kind of a pyramid approach where, the first tier would cover the majority, properties. Some would hit that second tier, and then a few would be in that third tier. Now it's almost a silo where, those values, they're all of our colleagues are hitting those 3 tiers, and they're all into that third tier, for example. So again, having your support to look at that and make those adjustments is critical. As Joel mentioned, I'll just talk on, we're up in the Cross Lake area. I have a map on my wall from 1968, and I have over 75 properties that were resorts at that time. There are less than 12 today, and of that 12, I know of 3 that probably won't be around in the next 5 to 6 years. Again, that's how those that can't afford lakeshore properties, we are the gateway for them to get to the lakes, which are public domain in the state of Minnesota here, and we hope to continue to do that. The colleagues that are here with us and our members of the Community Minnesota Resorts, that is our number 1 mission. Our communities rely on us to be there. We provide guests and, the people that come to our resorts spend the money in our communities as well. So they're reliant on us being around there as well. We've seen communities where the resorts no longer are. The number of attractions go down as well. You don't have the bait shops, you don't have the mini golf, you don't have the Dairy Queens, you don't have those type of facilities in those small towns. It's not just us, but that's what we help support in each of our communities. So I really appreciate your support here today, and I'll turn it over to the next one.
Thank you. Hello, my name is Beth Klinsky from Naughty Pines Resort in Nevis, Minnesota, Park Rapids area. I am a woman-owned business. I purchased the resort from my parents in 2021, and so it's been in our family for 19 years. They actually had it up for sale for about 5 years because we just didn't know if we were at the point we could take it over at that time. But they insisted that it stay at a resort, and so as their health declined, we saw they were getting closer and closer to just selling it off like we were talking about. And we knew the blood, sweat, and tears that goes into running the resort. And we've come to grow and know the families that come and visit year after year. I mean, they literally save all year long, and they wait all year long for their week at the lake. It's taking the kids fishing, it's the kids spending hours on end playing at the beach. It's, grandparents having that heart-to-heart with their grandkids. We get to see it all, and it's just, listening to the loons as the sun sets over the lake. Those are memories that they'll cherish forever. And And I just appreciate your time and understanding and your support in helping us keep this ma and pa resort business in business. It's not only me, but my husband and my 3 children run the day-to-day operations, and we also do hire some seasonal cleaners as well. And I know us personally, by keeping it a resort, we host about 135 families each year to the Park Rapids area that are shopping at the local shops, you know, getting their groceries at the local grocery stores. And so I think that's a big part of Minnesota history, is spending your week at the lake. So thank you for your support.
And our third testifier.
Great, thank you. Appreciate the opportunity to be here. My name is Ann Doherty, and I represent Womboats Cabins, along with my husband, James. We purchased Womboats, which was a Womboats Camp or Womboats Resort, also in the Park Rapids area, in 2002. It is one of the oldest resorts, certainly in Hubbard County, but they opened their doors in 1901. The cabins are still standing from that early turn of the century. It had been defunct for about 20 years. And so our story is a little bit different. I grew up on the lake in that area, and so was familiar with the property. So for about 20 years, we sort of expected that it was to be developed. And during the pandemic, my husband and I had a real soul-searching time of thinking about if there was an opportunity for our family. We have 5 children. Our oldest was a senior in high school at that point. To think about, could we hold it together? Was there a way to turn this into a viable business again? And as was mentioned previously, this is a short season. We're not a year-round resort. So we really have like 10 weeks. And so to be able to make it profitable in 10 weeks is a challenge, but it was something we were excited to try. The best surprise of this experience was that nobody had been there really for 20 years. It had been in private ownership. We weren't expecting any return guests. The best joy of this experience is the people that found us and have come back. They grew up there. They brought their grandchildren. They never thought that they were going to have an opportunity like this. The gift as a resort owner, to have people say to you, the happiest parts of my childhood were at this lake, on this beach, was a gift I didn't know that we were going to receive, and it's been magnificent. I'm also a high school entrepreneurship teacher, and I look at, you know, one, how do you make this work? And how do we model for our kids who don't have this lake experience, especially in our urban communities, access to this water? How do we help them think about, how do we get back to this? How do we create that lake culture again so that kids get to be barefoot and with grandma and grandpa, and just making those memories that make them, when they're adults, want to come back to the Minnesota Lake community again and make sure they continue those memories. So it's been a gift. I didn't grow up thinking that I wanted to own a resort, and it has been the very best decision of our lives, and I'm grateful that we've done it. Do you want to add anything? Great. Thank you for your time.
Thank you very much. One question I have is, on an average, can you tell us how much have your real estate taxes risen in the last few years?
Would you want to go
ahead.
first?
You start.
We've seen, again, our properties has changed quite a bit too, but I think we're up about 12% over last year. Is that right too, James?
From 2022 to 2025, it's a 50% increase in overall property taxes. So
Okay.
it's the single largest expense that we face as a business.
Okay. And Mr. Carlson, you mentioned about I forget the term that you used as far as the valuation and the tiers that are there. And I'm assuming that those tiers, are they set by the department or are they set by the legislature?
Mr. Chair and members, they're set by the legislature in Statute 273.
Okay.
13,
Okay.
22, I think it is, Mr. Sylvia. But yes, they're set by the legislature. After they were put in place in 2005, they were adjusted once in 2008, and they have not been adjusted since. So over the period of time, not just since the pandemic, but since 2005, the tiers just have not kept pace with the rapid increase in lakeshore property. And when you're, paying $10,000 of running foot for lakeshore and trying to run your resort, in a 10-week season, which can get condensed even shorter, it's a real challenge. So they're set by the legislature, and that's why we're asking you. I would love to have a conversation with the assessors about using a income approach to valuing these resorts and not just the highest and best use of breaking them up and selling them as individual properties. But that train may have left the station. So the only way that we can do it with the model that we have right now and to meet that objective of that model is to increase those tiers. And we're gonna, Senator Housechildt had a bill last year to do that, and we're gonna bring that forward again. We have to bump that number up every year when we don't ring the bell. And so it's critical that those are adjusted. So, but it's set in statute.
And obviously, members, you know, we are talking here about, there's a couple of things. There's a valuation question, and it's not that the assessors are doing anything incorrectly, because under the definition of appraisal, you know, you appraise the land as vacant and according to its highest and best use. And yet, the highest and best use, and it relates to the resorts, is winding up being a different value probably than what the land would bring if it was sold as a functioning resort. And or what you're doing is anyone that buys a resort is buying the land, and there needs to be a substantial diminution of value as it relates to the buildings. But that's an appraisal question to debate. And also, you know, provide relief. Would we create a shift? Yes, we would. I remember a couple years ago when I was chairing the property tax subcommittee, I had discussion with county officials from many of our high resort containing counties. And their comment was, this is a shift that we quite frankly know we are going to need to have in order to keep these businesses. And the reality of it is that if we lose our resorts, we're going to lose many of our other businesses as well, because of the support that their renters, their customers provide to the surrounding community. So, you know, it's a problem. It's a substantial problem. And I thought it was one that, as we talked about property taxes today, that we should highlight. Any other questions, members? Senator Drazkowski.
Thank you, Mr. Chair. Interesting discussion for the resort owners. So you went from 1,100 to 600. Where are the people going that were going to the other 500? What kind of tell us, are people recreating less? Are they going elsewhere? And I really appreciated the discussion you had about the interface of, you know, resort ownership versus potential private property and being gobbled up by that. But where are the people going? What are happening to the customers that are no longer being served by those 500 resorts?
Mr. Carlson?
Well, Mr. Chair and Senator Drazkowski, maybe a good question for Explore Minnesota Tourism as they track Minnesota as a destination and where people go. I can tell you that that our experience has been the rise of vacation rental homes has consumed some of the market, and others just don't have the opportunity to go to a resort any longer. So they're doing something else, whether they're traveling out of state and not spending their money here. That opportunity has been lost. And when you have 12 cabins and you're renting out to 135 or 140 families a year, and that becomes one private residence, that opportunity is lost. And we're not creating new resorts in Minnesota. So my big answer is that the opportunity is lost, Senator, in most instances.
Anyone else? Senator Housechildt.
Thank you, Mr. Chair, and I just want to say thank you. I think you guys run a really unique business in the sense that it really is, to your point, a public-private partnership for a public good. It's great that you guys are able to run a business and support your families, but it's also an experience for Minnesotans to see the best of what our state offers. personal story, my grandparents, I'm lucky enough, my grandparents have a cabin on Blanche Lake, which is in Glendalough State Park. It was sort of grandfathered in when the state park was created, but we're next to a resort. And so not only have throughout my life been able to experience all these families that come each year to the resort and get to interact with them and create friendships, but now my wife and I go and we rent those cabins when we go see our family. So we're able to enjoy the resort, enjoy our time at the lake, the best place in Minnesota for me growing up. But I also get to be next to our family. So I value what you guys do. It is shrinking. We're losing them up in northern Minnesota as well. And I think there's an opportunity for the state to say, we value this as a public good. We think what you are doing is good for tourism, but it's good for our people to have these experiences. And we should, in our tax policy, decide to make this a more of a public good by incentivizing you to stay in business. So appreciate what you do, and we'll keep working, Mr. Carlson, on this issue together. Thanks.
Very good. With that, that brings us to the end of our discussion today, unless there's any further questions or comments. I appreciate the opportunity I've had to chair this committee for a few times, and we will go back to our normal orders of business with Senator Ress as the chair from now on. And with that, everyone, this committee stands adjourned.
Thank you.